Yeah. hmm You know, this idea of judges believing something, yeah, what they actually think, yes, as being documented in a non-threatening environment, right, where you lead the individual into believing that you want to believe them, yeah. I think it's very important in protecting the courts, yes. Now, I know you're busy. That docket's full every day, and there's just not enough of you. Yeah. But you get one of these wrong, yes, then you find out exactly how expensive it gets. Ouch. Now, for every time I said, well, it's $100 billion day, and you said, no, it's not true. I can remove the actual assets of every judge of the United States. I think that the Congress may from time to time ordain and establish, yes, some new requirements for the mental health evaluation, yes, restoration laws, and the diagnosis, right, and then the treatment as required. Mhm. I really like, I dislike, yes, the idea of any judge having arrested any individual, yes, that happens to be a parent, yes, for refusal, to comply with court ordered treatment. Oh, I don't want anybody to go to a mental institution unless you're really, really insane. Yeah. And I want everybody to stand trial as long as you're competent. Yes. Now, if you can't have a conversation for 30 minutes with the judge, yes, I would, excuse me, yes. I would say that the judge probably has a strong belief that you have a mental issue. Yeah. Probably should order that 1077 and you may not be able to be restored. No. Now, for every judge that's afraid of being in the same room with the accused, yes, they have what's known as bailiffs. In fact, they could bring in 5 or 10 of them. They could just sit around you. Yes. And you can have a nice, quiet conversation with the judge without any fear that you're going to be able to hurt them. Now, this idea of being afraid of the accused or the respondent, yeah, I had noticed that there seems to be a lot of bailiffs in the actual courtroom. A couple different times they asked me to remove my hat. Oh, they suggested that I put my backpack in a locker. Yes, And if there's any question about any individual waiting to speak to the judge, yeah. Anytime you have a court case where either the prosecuting attorney or the public defender, yes, really questions the sanity of the accused, I think you should have a special docketed day where you decide to have a conversation on whether or not you believe the prosecuting attorney or the public defender. Now, of the 95% of the cases that are P bargained, yeah, it shouldn't be that more than 1% of the cases require the judge to have a conversation. And I think we can afford as a nation to give judges that availability of documenting why they think a mental health evaluation is a good idea. Because the next individual after me, oh, if we have another citizen of the United States that wants to challenge the judge's decisions, yes, I would like to establish, yes, a precedent, yes, that you will never order a mental health evaluation based upon the public defender or the prosecuting attorney without the judge personally believing the individual has some sort of mental issue. I'm sure of it. Yes. They have outbursts. Yeah. Uncontrollable. Uncontrollable. Just too loud, isn't it? Yes, it is. Seemed that some prosecuting attorneys, yep, thought it was so much easier to dismiss cases for incompetence because of their refusal to admit the evidence that the accused wasn't in those cities. Yeah. And the accused did not commit the crime of cyberstalking. Well, then there are the public defenders that can be bribed. Yeah. Whiny baby. Well, I tell them, okay, I want you to motion the court to have the protection order removed. Yes, approximately 1 week after being arraigned. Yeah. You're like, I can't do that. No. Well, here's a copy of it. Yes. I did not get any notice of court hearings. Well, we don't have to do that. The petitioner didn't sign it. I mean, how often does that happen? There's fraudulent statements that I received actual notice. There's the vine. There's the serving of someone other than the respondent. You would think, yes, that the respondent would get to know everyone that gets served a copy of the protection order. No, but not in this county. No, sirree. We don't do it that way. That's right. Now, for every judge that thinks that I'm being unnecessarily cautious in the judgment, the court ordered mental health evaluation, so, I'm going to establish an amount of liability to the judicial system of the United States to the tune of $1 trillion because you're going to do what I say. Oh. Let's see, Amendment number 4. But upon probable cause. Yes, there can be no probable cause that I was in Sequim, Washington. Isn't that right? Because I wasn't there. Yeah. There cannot be any probable cause of the 2-count criminal complaint because I wasn't in Jefferson County. Yep, that's right. And even though you want to say cyber stalking, I can give you 3 million emails and 1,500,000 emails. That I'd sent from October 20th of 2016 until approximately August 21st of 2017. In fact, from January 5th, yes, when I got out of jail after the arraignment, it's 1.5 million. It's probably like 700 to 800,000 from the time I got out of the 27 days of being in jail when you did that mental health evaluation on October 16th of 2016. Then there's depriving a life, liberty, of property without due process. For every mental health evaluation that you order as a judge that's going to deprive the individual of life, liberty, and property, I would think you'd want to protect their Fifth Amendment right so that you can say, well, I didn't violate that. Yes, I didn't violate Amendment number 4. No, I didn't violate Amendment number 6, the right to a speedy and public trial. I think a lot less prosecutors and public defenders are going to suggest to the judge, mental health. A lot of judges that think it's going to take hours and hours, possibly days, weeks, or months of their personal life to have to sit there and listen to the accused. Piece of shit. You'll find the prosecuting attorneys and public defenders, they'll want to get these trials done faster and faster and faster so as to make absolutely mother. Now, of all the plea bargains, that 4% that go to trial, yes, that's right. Judges will find that any time that they have to take in their personal time of the docket, yes, a half an hour to talk to the respondent, yes, or to talk to the accused so that they can actually prove to a jury of their peers, yes, that when I ordered the mental evaluation, I could see why the public defender thought the individual had a problem talking. Because every time I tried to talk to him, he just kept going round and round and round and just could not understand.